hasn't been said in the responses is which part of all of this is being brought in. So I've heard, to a certain degree, basic work, maybe not the review, right sizing, which suggests that it's not moving en masse in-house. So which portions do you see coming in-house, and then how do those relate to what Browning was talking about?
Well, I think as I said, for Netflix, we're a small company. I'm the only litigation attorney there. We have someone who's kind of a part-time person supporting me. So bringing in the review side of things, the right-hand side of the ERM isn't really very effective for us at cost or human resource levels. So, but what is useful for me is to have an ability to winnow down the data that I send out to the process, rather than pulling full gigabytes of mail, to narrowing that down to really what is potentially relevant, using in-house search terms, playing with those types of tools to save me cost down the road. So, but it may be a different story if you have an in-house litigation team that actually does litigation rather than just simply manage it. If you have a lot of bodies, it may make more sense to bring more of it in-house. I also bringing discovery in-house to me also means, just as I indicated before, getting more control of the outside vendors. So hiring directly document review teams, hiring the vendors directly, making sure that I have a direct relationship and I know what's going on with those vendors. So even though they're not technically in-house, I have much more input into what's going on.
Can I break the
go for it, please,
chain?
Please do.
I'll try and shout a little louder. Again, I pretty much agree. We have many more attorneys at PG&E than it sounds like Netflix does, but we also are more on the left side so far of the model in terms of doing things in-house. And there is a little bit of a difference in some of the different practice areas. I think our employment attorneys, they just see more activity in the e-discovery space. So I think in general, those attorneys are maybe a little bit ahead of some of the rest of us, some of the tort or commercial or even environmental attorneys. And again, echoing the comment, we particularly like to retain vendors ourselves. It helps us economically, it helps us up front, and it helps us along the way.
I want to add just one thing in terms of the left-hand side. I absolutely agree. I think that's where people are all headed, from information management on. And what I've been seeing personally is that more companies have been asking to essentially take IT out of the equation as much as possible. So they want more of an automated collection that obviously still has all the metadata tags, et cetera, but they don't want to have to contact IT for every little thing. Obviously, there's going to be some areas, some sort of silos of data within a company that you're going to have to contact IT. That's just how it is. But they don't want to have to contact IT for every single little thing to go and collect this information. They want to find a way to do it otherwise. And so one of the other things that I noticed, especially at eBay, is what we're trying to do is not just do culling, but also do some sort of classification of the documents, so that when we handed them to the reviewers, we were handing them to them in a way that was just a little more intelligent. They were about 3 issues instead of about all 20 issues. So we were trying to somehow categorize them, even in wide swaths, because we didn't want to ultimately take the responsibility or frankly the legal risk of saying we're doing all the review or anything like that. But we wanted to be able to sort of put them into big buckets and say, now when you have a reviewer, this reviewer can really concentrate on just these smaller issues. And they don't have to look at the whole entire case and try to separate every single one.
So Eric and Browning, then, if the folks in-house are trying to pull under their control more and more of the activities on the left-hand side, where does that leave you, especially if you need to go into court down the road and make some representations about what was done by whom when?
Trust but verify. We're seeing clients getting more and more involved internally with litigation hold, surveying the potentially relevant data repositories, identifying custodians as to whom there may be relevant records. And that's all fine, but if we get taken out of the picture and things go awry, get into the Qualcomm realm, fingers pointing at one another. Was the client, was the law firm, who got it wrong, who should be sanctioned, was there spoliation? We don't ever want to be there. So, we have to be hand in hand. To the extent more is being shouldered in-house, that can be okay if done appropriately, but we need to understand what's happening and be able to help guide it as well, because we have things to say that are helpful to the client. So, Browning, I wonder if that's your experience too.
Well, it is. We had an interesting opportunity to respond to an RFP for a large organization, and they described that they had a very robust internal process. They did their own internal review. It was really one of the most developed that I had seen. But in sort of responding to it, I said to the folks drafting it, I said, it really is trust but verify. And so, we better build in some time to go in and kick the tires of the process, look at the workflows. Is it in fact something that we can salute? And then when it came to the review process, which as I think everybody acknowledges is the single most expensive part of it. I mean, it's like, what, 70, 75% of the costs associated with electronic discovery lie in is to make sure that we had somebody in the firm, probably a senior associate, junior partner, that was going to be intimately involved with the review, notwithstanding that the bulk of it would be done by the organization. So that at least we could say we were there, we participated, and were active participants.
There is a theoretical, at least, model that I have not seen used very much with respect to electronic discovery. But I'm going to put this out there, and then what I want are some thoughts about the trust but verify. Just how much trust, just how much verification, and who's really got the legal risk in all of this. 20-some years ago, we did work for two clients, products liability litigation. One of them involved motorcycles, ATVs, and the like. When we got the discovery requests, we had X number of days to fax or mail them. It was very primitive in those days. And then we would get back a package from the client of the documents that we were allowed to produce in that case. We were not allowed to talk with anybody, interview anyone, question whether the scope of this production was appropriate. There was never a problem with that. Now, maybe there was never a problem because the plaintiff's attorneys knew generally to within about 30 seconds at what point the in-house attorney would call them directly and settle the case. So maybe that was some of what was going on. In another case, outside counsel performed that same role. So we would send them the discovery requests. They would deliver us the documents and the written discovery responses, which we could change just stylistically, but not substantively. There, we weren't given any ability to verify. We had to trust, and they both said, look, if you don't like it, there are a lot of other law firms around town. So fast forward to today, these issues are much more high profile than then. The volumes of data, of course, that we're dealing with much greater, and the amount of money at issue much larger. So would that approach work here? Where would the trust be? Where would the verification be? How much of each? And who's really carrying the risks?
I wouldn't want that situation. Both working from in-house or being an outside counsel, I wouldn't want that situation. Because I basically want to be able to share the risk, essentially, right? I mean, that's the way it has to be. So I wouldn't want that kind of situation. I certainly, in-house, you're really stuck between a rock and the budget. And so you really can't ask the in-house partner, or the outside partner, I mean, to come in and, basically run them up and spend 100 hours verifying everything. But you have to build in something into the budget to say they're going to need to come in, because it's the outside counsel that signed the form that's saying, in fact, I did a reasonable and diligent search, and it's not the in-house counsel that signed it.
Well, let me add something. In both those situations, in one where there was National Coordinating Council, they were signing. In the other, the in-house attorney signed.
I didn't sign it.